But do you need to register a trademark? Well, in short, no. Trademarks don't have to be registered. But would you want to register a trademark? Probably yes. So if you're thinking about things like protecting your brand, building goodwill in that brand, and defending your trademark from your competitors, the rights that you get from registration really now dominate as the main vehicle to be able to do that in any kind of easy way. Because the Trademark Act gives a clear path for protection, offensive action, and defensive action of your trademark. If you don't register a trademark, you can still do this, but you're going to have to rely on other legislation and common law, such as the Fair Trading Act and the tort of passing off. The difficulty with these is that you're going to have to prove sufficient reputation and confusion, which, while likely possible, is going to be a much higher standard to reach. Now, Jason's going to cover off the benefits of registration a little bit later in a more specific context. But some of the things that are obvious benefits to registration include the exclusivity to use that you get upon a trademark registration, that legal protection to deter others from using your brand or imitating your brand, and it just adds value to your business that can increase over time as the mark becomes established in the marketplace and develops a reputation. That's commonly known as goodwill, but the trademark itself can develop value. If you're looking at registered and unregistered trademarks, you also likely see often the R symbol that you can see on the slide there, known as the rondel or the little TM sign. Now, if you've got a registered trademark, you're allowed to use the rondel sign. If it's unregistered, you're not. You can only use the TM sign. Of course, if you have a registered trademark, you don't have to use the rondel sign. You can use the trademark. There's no real reason why you would do either except for to flag out there that it's a registered trademark. Why would you use the TM sign? Well, a lot of people would use it as a way to claim ownership, essentially, over that brand, as a way to let others know that you're trying to say that this is unique to you. Does it do anything? Well, it may in certain circumstances. And in terms of the registration process itself, registration of trademarks is a territorial process. So that means you need to register in each country or jurisdiction where you want to or need to have protection. Registration of trademarks in New Zealand is dealt with under the Trademarks Act. Essentially, you apply for your trademark. That trademark is examined by the Intellectual Property Office of New Zealand against certain criteria. And if it's not opposed or you don't face any issues that you can't overcome, you get a registration. When you're applying for your trademark, you need to apply for it for protection in respect of the goods and services that you intend to actually apply that trademark for. Getting the goods and services correct is really important because this defines the infringement rights that you have. This is something that we can also help you with. So if you have any questions, feel free to come and ask us. The classification system is for the classes. So there's 45 classes overall. This is broken down into 34 classes known as goods and then 11 classes that are known as services. This classification system is based on an international regime published by the World Intellectual Property Office, known as the NICE classification system, which is good because it means that internationally there is a recognized system of defining the goods and services. So each jurisdiction may have its own way of interpreting that or applying it. In terms of the type of classes that you might get, these are broken down into things, for example, like software and related goods, hardware, retail and wholesale services, advertising services, financial service. Each are given their own class of related goods, and you can apply for as many or as few as you like that you intend to use. If you do succeed in getting a trademark, well, you can essentially have it forever, provided that you continue to use the trademark and you pay the registration fees. You are given registration in blocks of 10-year periods taken from the date where you're deemed to have been registered, which is when you applied for your trademark. In terms of actually registering a trademark, I mentioned earlier that in addition to being able to be represented graphically, it also must be able to be capable of registration. So there's a number of objective and relative grounds that must also be met when you're applying for a trademark. The trademark obviously must be capable of distinguishing your goods and services from those of another. The trademark you're wanting to use cannot be so inherently generic in relation to the particular goods and services, such that there's no way that that trademark could actually denote the trade origin of them. The trademark also must have distinctive character. You can think of it like, are other traders likely to want to use the same or very similar trademark in connection with their own goods and services in the ordinary course of the business, and it's reasonable to expect for that. For example, is it so descriptive of what the goods and services are that it would be unreasonable for one person to have exclusive rights to use that trademark? There's a lot of crossover there with distinguishing it, because if it's so descriptive, then it's unlikely to be able to distinguish where the trade origin actually is. It's often referred to as, does the trademark communicate a badge of origin, which is a good way to think about, does that trademark identify you as a company and what you produce? The trademark also must not be just generally descriptive, so it can't essentially describe the kind of goods, the quality of the goods, the geographical origin, when those goods and services will be delivered. Quickly, for example, can often be problematic. You need to think about, would an average consumer regard the trademark as a normal way of describing those goods and services? There's also a few additional things that also get taken into consideration that don't delve into just the overall nature of whether a trademark is capable of registration. For example, the mark can't be deceptive. It can't be a mark that's going to deceive or confuse the public as to what either the products itself or in relation to other products in the market. It mustn't be contrary to New Zealand law. It shouldn't offend a large portion of the public. And the application must also not be made in bad faith. So you must actually have the right to apply to own the trademark. Okay, so I think we can talk about some benefits of registration.
Thanks, Rachel. It's great.